Yes. Shut up, Anna Paula.
Okay, so my court case is Duncan versus Louisiana.
You're gonna kill it. Good job.
So the question is, was the state of Louisiana obligated to provide a jury trial in criminal cases such as Duncan's? And the answer is yes, as you will see. So it was argued January 17th, 1968, and decided on May 20th, 1968. The petitioner was Gary Duncan, and the respondent was the state of Louisiana. Gary Duncan, a black man in Louisiana, was driving on the highway when he saw two of his cousins on the side of the road, and he saw that they were talking to four white males, so that was pretty alarming to him. He knew that his cousins had recently transferred to a formerly all-white school, and they had reported instances of racial dispute. And so because of this, Duncan got out of his car to check on his cousins, and he told them to leave with him. Herman Landry, one of the white males, accused Duncan of slapping him on the elbow, and his fellow white friends also testified to this, and Duncan and his cousins testified that Duncan barely touched Landry. The judge found Duncan guilty of assault by a trial judge. The judge concluded that the state had proved beyond a reasonable doubt that Duncan did commit the crime. Duncan was convicted of simple battery, which in Louisiana is a misdemeanor, which is punishable by a maximum of 2 years in prison and a $300 fine. He was actually sentenced to 60 days, and he was fined $150. Duncan requested a jury trial and was denied because of the Louisiana Constitution. This grants jury trials only in cases where capital punishment or imprisonment at hard labor may be imposed. Because of this, Duncan sought for the review of the Supreme Court of Louisiana. They found that there was no error in ruling and therefore denied Duncan a right of certiorari. This is an order by which a higher court reviews the lower court, and then Duncan appealed to the Supreme Court of the United States. Duncan believed that his 6th and 14th Amendment rights were violated, and he felt that a crime with a maximum of 2 years in prison should be a serious enough crime to have a jury trial. The Sixth Amendment is the right to a speedy trial by an impartial jury, and the 14th Amendment denies the states the power to deprive any person of life, liberty, or property without due process of law. The state's argument was that it's really expensive to grant jury trials to every criminal case, and they don't think it is smart to allow an ordinary person to determine someone's fate. The decision, Justice Brian White delivered the opinion of the Supreme Court of the United States, and 7 votes were for Duncan, and then 2 were against. The 2 people that were against said that the right to a jury trial varies from state to state, and that the state should be allowed to govern its own citizens. And if its own citizens want the right to a jury in all criminal cases, they can seek it through political process. But they did, however, decide that smaller crimes that are punishable with a maximum of 6 months in prison and a $500 fine were not able to have a jury trial. This case was a key component for the Supreme Court to make all states comply with the amendments of the United States. A trial by jury is fundamental to the American scheme of justice, and it reduces the possibility of arbitrary with judges. A similar case is Singer versus United States. In the United States, John F. Singer was charged with 30 counts of mail fraud, and he decided that he didn't want a jury trial and he just wanted to be presented to a judge alone. And they decided that the Supreme Court held that the Constitution neither grants or recognizes a right of defendants to have their own cases decided by a judge alone.
Constitution, it says that people have the right to